Good morning. Today is Thursday, September 18th, 2025, and welcome to our regular meeting of the California Fair Political Practices Commission. Ms. Vo, will you please take roll?
Yep. Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yep.
Commissioner Wilson?
Here.
Commissioner Zettel?
Here.
Chair Silver?
Here. Excellent. Let's move on to item number 1, and that's going to be public comment for items not on today's agenda. Do we have any public comment for items not on today's agenda? Okay, hearing and seeing none. Just some surprise from our executive director. Let's move on to item number 2, and that's going to be approval of our August 2025 commission meeting minutes. Do any commissioners have suggested edits or changes to those minutes? Commissioner Wilson.
I move the adoption of the minutes.
Second.
Ms. Vo.
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Commissioner Zettel?
Aye.
Chair Silver?
Aye.
Motion passes.
Excellent. Let's move on to our consent calendar, and that's going to be items 3 through 6, though I believe we do have an update on that calendar that our new chief enforcement is going to run through. So I'd like to take this opportunity to introduce our new chief enforcement, Kendall Bonebrake. I personally believe that the enforcement chief is one of the most important positions at the commission. Consistent with that, we conducted an extensive nationwide search to identify the right leader for this role. I felt almost immediately that Chief Bonebrake was the ideal fit for it, given her familiarity with the act, her extensive management experience, and her stellar reputation. So I'm glad you decided to accept our offer. Welcome to the commission. I look forward to working with you and building on the enforcement division's recent successes.
Thank you, Chair. Thank you, Chair Silver, Commissioners. I am privileged to act as your new enforcement chief and continue the great work of both the commission and the enforcement division. I also want to take this opportunity to thank both of our assistant chiefs, Angela Brereton and Christopher Burton, who have stepped in to lead the enforcement division in the absence of a chief. They have done an excellent job for the last several months, and I am excited to work with them moving forward and the commission.
Excellent. Before we delve into the consent calendar, do we have any updates as to any items on the consent calendar? Items 3 through 6?
Yes, Chair Silver, Commissioners, we have just 2 updates. Number 1, on the City of Hanford stipulation, which is item number 4. We did catch a typographical error when we reviewed the similar matters. The Garden Grove matter, there are 2 references to the mailer in that matter, and the cost of that, one was $11,000, one was $1.5 thousand. The correct number is the $1.5 thousand. We've already reached out to the City of Hanford and made that correction, but is not reflected. I'm sorry, page. Let's see. That is a very good question. Wrong. Give me 1 second. I need to locate that.
So it looks to me like it's page 12 where there's discussion of the comparable case of City of Garden Grove.
Correct. That's right. I thought I had circled it, but I am not looking at it correctly.
And then the correct number is, because
It is the 1.5.
Okay, so the 1,526?
Correct.
Okay, excellent. Thank you for that clarification.
The second is the default that we had in front of you today. Mr. Minix reached out yesterday and asked that we take it off calendar today and attempt to settle. So our proposal is that we remove it from today's calendar, and then we will bring it back to you at a later date for either a main line if we're able to settle, or if not, for a default in the future.
Okay, great. That's excellent news. I'd much prefer to resolve these sorts of matters through the typical enforcement process rather than default. And I believe, and just General Counsel, if you can confirm, no motion is necessary to pull item 6 from the agenda, correct?
That's correct. Just when the consent calendar will now be items 1 through 5.
Perfect.
Or 3 through 5, sorry.
Okay, so why don't we consider the consent calendar, which is now items 3 through 5. Before general discussion of the consent calendar, are there any items that Commissioner would like to pull?
No,
No.
not like to pull, but I'd like to discuss one.
Okay, perfect. Here we have 2 cases that deal with some of the most serious violations of the act, and we tell staff and enforcement chief, these are the types of violations we want to devote our resources to, right? So I thought it'd be helpful for you to briefly run through the circumstances here and the types of public harm you see with mass mailings at public expense and laundered campaign contributions in Hanford and Tressman respectively.
Absolutely. So we'll start with Treisman as it's the first on the agenda. So in that case, Treisman was running for Fresno County judge. And Treisman's father actually loaned Treisman $30,000. Treisman deposited this money into his personal bank account, and then he wrote a check to his committee for the $30,000. He indicated to his committee, by both representation and report on the campaign statements, that the loan was from him. And so at no time did he disclose publicly, as part of his campaign committee, the true source of the loan being his father. The City of Hanford case. The City of Hanford, as many of you know, is the most populous city in Kings County. Kings County had moved a measure to increase the sales tax in Kings County. That was on the ballot as Measure F. And the measure ended up being defeated. Approximately 12 days prior to the vote on Measure F, the city, they actually contracted with a company to mail out a mailer to approximately 18,150 local residents. And that mailer cost approximately $2,000, $1,958.39 to be exact. This was sent as part of the utility billing for the city's customers. And again, 12 days before the election. The mailer did not include any of the proper advertisement disclosures, for example, ad paid for by and the name of the committee. Also, the committee never filed the 24-hour required expenditure, in this case, independent expenditure report, nor did they file a semi-annual campaign statement advising the public that they were the true source of this advertisement.
Excellent. Thank you for that. Commissioner Brandt.
Yes, I want to comment on the Hanford one. So we had a case, as you know, that is in consideration last month as well from the city of Norco. And I want to comment generally on this one because I initially read the stipulation and thought, oh yeah, of course, that's obvious. But then I ultimately went and read the piece, and I started to see why there may be arguments, but this still remains one. And part of this is I want to share that I have been part of writing these kinds of things. When I was in the legislature, I wrote, one of the challenging ones was writing the 2014 water bond, and doing a description and doing a kind of a 2-page description that we could give to members to say why they support it and why they do it. They do on their own. But I was working on state time. I needed to do this so I was very careful. I talked to council about legislative council, and I wrote it, but it was positive. It was all positive, but it was all the facts. And I also looked at some other cases at that point on what we could do with, because we had findings in the water bond, in the actual water bond, and we've done some things about why this is a great thing. So I come out on these things that if you're facts, then you're good. And that may be that there is in the resolution that the city council passes, they may take a position. And they may say things, and they may have opinions even, potentially. But if you're stating the facts of this is what the council said, that may be fine. You don't have to be even-handed. You can be that, but it's got to be facts. And so then when I went to the Hanford mailer, and could we put that up, please, on the screen? And this, I now understood why they thought, well, maybe this passes, because this mailer focuses on the facts, and so even the no, and I saw what they were doing is like no F, because they then continue with the facts, but it was no F was in bold, and so it's like it's still a clear case for me. But I see now, and those who are out there thinking about, where do I draw the line? If you can draw the line on facts, and that may even be facts about an opinion of the body or something like that, that may be okay. But this kind of no F, it's just so clearly a campaign mailer when you look at it. But I see where they said follow it with facts. So you can see no major F money will be allocated to the Hanford Fire Department. So that was a fact. But it's these 4 lines of in bold, no major F. That's telling people how to vote, and that really was what it was. But I was so that's kind of it. So I just want to say, and kind of where I'm going to be going with these kinds of things is, if they're focused on facts, I'm going to be, that's going to be okay. And yeah, there is the style, or the 3 style.
Style, tenor, and timing.
Style, tenor, and timing. Yes, we can look at those, and that may be fine. And this is 12 days before. I mean, that's why this is an obvious case. This is 12 days before the election. I was writing in early September for the November ballot, a couple months before. But I'd say that's kind of where I am, and that's where I'm going to come out on enforcement. Is if it's focused on facts, and I'm okay with the style, timing, and tenor, then that may be fine. But that's kind of where I am. I don't need to see that, they took the other side too. That doesn't have to be even-handed, as long as it's focused on facts. So just kind of wanted to give you that sense as you go forward on enforcement.
Commissioner Wilson?
Well, first of all, welcome, Chief Bonebreak, on your new position. Look forward to working with you. But as a follow-up to what Commissioner Brandt had to say, I don't gather, though, that the analysis that you wrote was sent out as a mass mailing by the legislature, or was it?
It was used that way. And so it was, in other words, I sent it out to all members and all staff and for the legislature, and members used it as a tool to.
Yeah, but as a talking point, though.
Right, as a talking point, but there may have been some who sent them out an email. I mean, that kind of thing, to kind of say, this is why this is good.
Okay, just kind of for clarification, since I've been on the commission, there have been a number of these cases that have come up. This is one of the first that I can recall where the locality advocated against the actual measure. And I agree with Commissioner Brandt. When you read this mailing, it is clearly advocating no on Measure F. If I'm a constituent in that district and I want to have my representatives give me factual information that I can use to determine how I'm going to vote, the equitable way to do it, based on how the law has been explained, by legal staff with the FPPC, if it's a balanced analysis, then that's different. But if it's one-sided, advocating yes or no, it's just a clever way to get a campaign mailer out at public expense. Now, it might be a great idea that mass mailing should go out at public expense. Then the law should be changed to clarify that, because the regulations that are in place are based on legislation adopted by the legislature. So I think, as a follow-up to Commissioner Brandt, we have to look at these on a case-by-case basis. But in this particular case, it was clearly advocating a no position. And you had said that most of us know that Hanford's the largest city in Kings County. I didn't know that until I read the stipulation, but thank you.
And I think one great thing about the commission is that we all bring our own, experience and perspective to analysis of the act, right? But we do follow the relevant statutes and regulations. In particular, when we're talking about mass mailings at the public expense, we're looking at regulation, I believe, 18901.1, where we look at specific factors and criteria, right? Like we discussed, style, tenor, and timing. We're just not looking at whether the information provided is a fact. If, for instance, a jurisdiction decides to send out for the first time 12 mailings in 1 week reminding people that it's election day and there is in fact a ballot measure on the ballot, that is factual. However, that would, in my estimation, in general example, be a violation based on style, tenor, and timing. Certainly something I would consider in terms of the timing factor there. And the consistency with past practices in terms of how many communications have been sent. So I think what's clear is that whenever we're looking at these types of cases, that we're looking at those criteria provided in regulation.
Right. Can I follow up on both of
Sure,
your
Brant.
comments? So yes, and that's where it is, are they telling them how to vote? And the style, tenor, and timing may be it. But Commissioner Wilson, I disagree, and I think our cases are a history here. You're not required to give the other side. You can't advocate one way or another, but you can provide all the facts that may lead you in that direction. I mean, I look at the case we looked at, the historical case. Was it Salinas that had all these horrible things were going to happen if it didn't pass? But it wasn't. And that was okay, and it was consistent with what the city had sent out before. And so style, tenor, and timing wasn't an issue. But it didn't have, this would cost more. It didn't have any of those things. So it's not about, it doesn't have to be even-handed in my view, and that's what I look at the cases. It's more about whether they're telling you to go and say and vote one way or another. And that may be the clues, like this one was the bolded no F. That one was one. Style, tenor, and timing may be another piece. So there are those kinds of things. That's where I think we need to draw the line. But I'm going to be more comfortable with facts, even if they are skewed one direction, as long as it doesn't go and say vote or there are other reasons to interpret it as being a vote one way or another.
Well, my response is I'm looking forward to seeing that first mass mailing sent out by a locality or county, whatever the case may be, that comes within the scope of what you're saying. The ones that I've seen, I'm only been on the commission a couple of years, it's been clear from each of the cases that have come before the FPPC that you should either vote, in most cases, vote yes. So if you had one that didn't say how to vote, then I think you're on point. Still waiting to see that one, though.
Okay, fair enough. And that's why we'll look forward to seeing. But that's as our welcome to our new enforcement chief, and that's the kind of challenge you're going to be. And perhaps we won't see it because it'll be, this is fine. I don't know. Anyway, but that's kind of, I just wanted to give a kind of heads up and to the broader community as well, kind of where I'm going to be looking.
Thank you, Commissioner Brandt.
Just a comment. Welcome to especially dealing with this thing. I think there is a lot of confusion what is permissible. I mean, and you can see it in here. We're going to have to deal with that, I think, with the confusion, providing some clarity because it's not clear. Thank you.
I agree to a certain extent. The good thing is that we have clear regulations and criteria to consider, but it's a difficult, complex analysis, right? And to address that, what we've done is you'll note here in the past, you wouldn't be able to take a look at this mailer right here to make that analysis that you laid out, Commissioner Brandt. And we've required that those are posted. We're doing the same thing with advice letters. We have an extensive discussion of these rules along with past enforcement cases on the topic, as well as advice letters on our website. So I'm really proud of all the materials that we've collected and produced over the years. We also engage with different interested parties and stakeholders on this. In the past, we've done presentations with the Institute of Local Government to address situations that have arisen. That's something we're planning to do in the future as well, generally. For any public attorneys out there who are advising on this specific topic, we'd always recommend what you do is if you're in a situation like this, you reach out to the FPPC for advice, and then we can advise you as to what is permissible under the law, and that eliminates that ambiguity. To the extent that you don't have time to do so, it would be my personal recommendation that you always err on the side of caution here. You don't even want to give the appearance of a misuse of public funds for a campaign purpose, because that undermines public trust, right? It creates the appearance for the public that the government is taking sides in an election, which is completely inappropriate. So with that, do we have public comment on the consent calendar? Okay. I'm going to move to approve the consent calendar, which is going to be items 3 through 5. Yeah.
Second.
Have a second? Excellent.
Yeah.
Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Commissioner Zettel,
Aye.
Chair Silver,
Aye.
motion passes.
And welcome,
Okay.
Kendall.
Item number 7, I am going to pull item number 7 for further consideration before we take that up for pre-notice based on some additional information we received from the party that suggested the regulatory change. So then we are going to move on to item number 8, and that's going to be adoption of amendments to Regulation 18351, FPPC Conflict of Interest Code. And up at the table, we're going to have Lindsay Rice, Manager, Email Advice Conflict of Interest Code Program in the Legal Division. Welcome to the table for the first time, I believe. Ms. Rice, good morning.
Hello. So I am Lindsay Rice, manager of the Email Advice and Conflict of Interest Code Program, and I am here to present the proposed amendments to Regulation 18351 to update the FPPC's Conflict of Interest Code. Every state agency is required to review its Conflict of Interest Code every 2 years and amend if there have been any substantive changes. We reached out to all of the division heads to confirm if any positions needed to be added or updated, and we are amending the code to add the new senior management auditor position in the Audits and Assistance Division, adding the electronic filing language for the commissioners, which is required under Government Code Section 87500B1, and making other non-substantive changes, which includes retitling existing positions and updating the standard language for consistency. So I am submitting the proposed regulation for adoption, and let me know if you have any questions.
Excellent. Do we have any questions from commissioners? Do we have any public comment on this item? Hearing and seeing none. I am going to go ahead and move approval.
And I second it as usual.
Ms. Bo?
And I second it.
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Commissioner Zettel,
Aye.
Chair Silver,
Aye.
motion passes.
Okay, thank you, Ms. Rice. Now we're going to move on to our FPPC Streamline program, how it works presentation. This is going to be part 1 in a 3-part presentation on this topic. And today we're going to hear from Senior Commission Counsel, Teresa Gilbertson, and Jonathan Riviera, Commission Counsel with the Enforcement Division. Good morning.
Good morning. Good morning, Chair and Commissioners. All right. I'll wait for the presentation. All right, so today's presentation will be the first of 3. We're going to be sharing an overview of the Enforcement Division procedures and, more importantly, the Streamline program. We will try to pause after each slide to give you an opportunity to ask any questions that you might have, and we'll be taking questions at the end of the presentation. My name is Teresa Gilbertson, as already introduced, Senior Commission Counsel.
And my name is Jonathan Rivera, just Commission Counsel.
All right. So again, today we're going to go over the enforcement procedures and the Streamline program. And then I've got a little overview on the next slide. So the purpose of these presentation series. So today is an overview, hopefully pretty high level. In October, we're going to talk about the Streamline violations that are eligible, specifically campaign. And then in November, so we don't overwhelm you in one meeting, because there are a few, we're going to talk about the ethics and lobbying violations, as well as finishing up with campaign, because again, there's a few. So the enforcement division, just to give you guys an idea of how we work. So we have 3 specialized teams. We are led by our chief of enforcement and aided greatly by our chief aide, Carly. We have our intake team, which has 2 managers, 5 attorneys, and 8 analysts. We've got the prosecutions team. I'm on the prosecutions team. Jonathan is on the intake team. With prosecutions, we just have 1 manager, 9 attorneys, and 3 analysts. And then we have our very important investigators. They have 2 managers, 10 investigators helping us with our work, 1 analyst, and this summer we have 2 interns. All right.
So the intake staff address all of the complaints filed by the public. The public can file sworn or non-sworn complaints. A sworn complaint is given under penalty of perjury, and the complainant will receive notice from the enforcement division about the status of the complaint, if a case is open, and when that case is resolved. We typically have 14 days to respond to a complaint, though we may take additional time if necessary to review various or complex violations, as well as allowing the respondent additional time for their response. Non-sworn complaints are not given under penalty of perjury, and the complainant will not be given notice regarding the status of the complaint or when it is resolved. When filing a non-sworn complaint, the complainant may choose to remain anonymous if that is their preference. When a complainant has selected to remain anonymous, there are instances that the complainant will include their contact information in their anonymous complaint, and that information must be made publicly available. If the complaint truly wants to remain anonymous, they cannot include this information, or else we may be forced to provide it. When reviewing a complaint, staff may take time to review additional violations that weren't alleged if there is evidence pointing to a potential violation of the act. There are a few other ways in which we may initiate a case. One example is what we call a spin-off case. We may have an open case, and during the investigation, we discover that another party has violated the act. We will open a spin-off case so that we may address that party's violations. For example, we will sometimes open major donor non-filer cases if we are working on a large campaign case. In campaign money laundering cases, they often result in the opening of several spin-off cases as we identify new potential respondents during an investigation. There may also be press coverage of something within our jurisdiction. For example, a staff is reading or watching the news, they may notice a potential violation of the act. After informing their supervisor, this may result in a case being opened. Next is cooperation with DAs and other law enforcement agencies. We may receive tips from law enforcement who will provide us with information about a potential violation, which may be sufficient to open a case. And another manner is a program we created. Under our AdWatch program, members of the public can submit advertisements and communication for enforcement staff to review to determine if the advertisement is compliant with the Act's various requirements. Such examples include yard signs, flyers, text messages, websites, social media posts, radio and TV ads, as well as other forms of communication.
Can I ask a question about that? I mean, are we asking questions or, okay.
Yeah, of course.
Give me the sense of how many AdWatch submissions do we get? I mean, give me the sense of size. I don't need specific numbers, just.
So normally, if we don't have an election, there may be one that pops up if there's some local issue. But as we get closer to an election, such as right now when we're in the 90 days, it tends to ramp up as we get closer to an election. So right now we may receive a couple a week, and then as we get closer to early October, end of October, and November, we'll receive multiple submissions a week.
Okay, thank you.
We also receive referrals from filing officers, and this tends to make up a majority of submissions that the intake staff process. Filing officers include the secretaries of state, as well as city or county clerks and other entities. If a filing officer has tried and failed to get the filer to come into compliance, the filing officer can refer the filer to the FPPC. Additionally, we receive audits and reports from the Franchise Tax Board's Political Reform Division and our own Audit Division. If either have found a violation, they will send us a report of their findings, and we may open a case based on their findings. So as we just discussed, a major part of intake staff's work is evaluating complaints and referrals to determine whether it is appropriate to open a case. They consider information included in the complaint, publicly available information, any material or attachments submitted with the complaint, and any additional information provided by the complainant, unless it warrants the opening of a new separate case. This is determined based on the information provided and the allegations alleged. The work can include reviewing whether a referral is complete and accurate, or whether a multi-page complaint with pages and pages of evidence attached articulates a prosecutable violation within our jurisdiction. If there is sufficient evidence to suggest a violation may have occurred, a case is opened. Sufficient evidence varies based on the allegations as well as the violations. Intake staff and attorneys also manage a caseload. Typically, these are cases that can be fully analyzed using publicly available information and generally do not require a special investigator. These cases will often qualify for Streamline or PrEP.
Yes.
Commissioner Ortiz?
I assume the intakes are in writing. What happens if somebody's calling you and say, oh, this person is violating? Do you take phone calls?
We do ask people to submit through our complaint portal
In
on
writing.
the website. Yes.
Thank you.
Before we get back to the presentation, I thought it'd be worth noting that if the public's interested to look at our statistics in terms of referrals received, complaints, the different types of complaints we receive, they can take a look at the Enforcement Division's executive staff report, and all that data is laid out each month. Go ahead.
And it will show the historical record as well.
There you go.
All right. So I'm going to talk a little bit about the role of the prosecution staff. So certain cases will be transferred from intake to prosecutions. These cases will include cases that need a special investigator. These are going to be handled by the prosecutions team. The investigators will go and obtain evidence through voluntary request or by administrative subpoena. In addition, cases can sometimes get transferred if they just need to be litigated. So the intake staff will try to work these cases. They will try to reach a settlement just with the evidence that they have and working with the respondent. But if they don't hear from the respondent or the settlement is not successful, it gets transferred to prosecutions so that we can begin to prosecute the case. We'll file a report in support of probable cause, a finding of probable cause. We also transfer cases just to keep the caseloads balanced and fair between the two teams. So the Enforcement Division's goal with cases is ultimately to reach a final resolution. This can come about a number of different ways. So first, a mainline settlement is our primary settlement document for cases. This document will include an admission by the respondent to those violations. It's an agreement between the Enforcement Division and the respondent about the relevant facts. There's public disclosure that's provided through that narrative, and the respondent has to, at times, depending on the violation, provide amendments, or they have to file those late campaign statements. That way we do have full disclosure, both where people are expecting it as well as in the document itself. The respondents have to fully pay the proposed monetary penalty.
We have a question, Commissioner Zettel?
Oh, yes.
Thank you. Just briefly, I was wondering if parties, respondents to the complaint, agree to stipulation and all of this, this process. Does that assist them in, it appears to assist them in mitigating the amount of the violation penalty, the fiscal amount?
If I understand your question correctly, if someone is settling with us, will they get a more favorable settlement versus the alternative? The answer is yes, which I'll discuss a little bit more on the next slide when we talk about some of the alternatives. Yes. So they do, by the time it comes to you, they will have fully paid. Mainline penalties are typically higher than other types of settlement agreements. And of course, the mainline stipulations are noticed and approved by the commissioners. All right. Oop, oh gosh. What did I do?
And we're done.
I got too excited. Okay, sorry about that. So another type of resolution to a case is our default judgment. So this is when if we're unable to reach that settlement but we have found violations at issue that require a judgment and a penalty, we will seek that judgment. So if a respondent fails to request a hearing, that's how we get to a default. And at the directive of the commission, we will typically seek penalties at maximum fine or near max for all or most of the identified violations in the case. We do rely on past defaults to look for what is an appropriate final proposed penalty. Another way that the case can appear is we'll have a judgment after an administrative hearing. So people can take us to hearing if they contest our position on the case. The commission also has authority to seek civil action. These are going to be reserved for the most egregious cases. They're fairly rare. We can also refer to law enforcement. So we can refer cases, and we do, to the Attorney General's office or the District Attorney's office. At times, we will seek a concurrent administrative resolution while we work with law enforcement. And then finally, on this slide, some cases are closed with different types of closure letters. For example, advisory or no action.
Commissioner Ortiz?
Thank you. How often do you refer cases to the Attorney General, District Attorneys?
It's not super frequent, but if we find a case that we feel that an administrative penalty or we need more resources to investigate the case, we do reach out to law enforcement. Some cases are automatically referred, like conflict of interest cases.
Which cases are automatically referred?
The conflict of interest cases.
Oh, okay. Interesting.
Commissioner Wilson?
Yes, Counsel, Senior Commission Counsel Gilbertson, if a case is referred to the District Attorney or the Attorney General, is the full commission notified at some point of that action, or because the matter doesn't come before the full commission? So I was just curious, what's the notification process, if any?
I don't believe there is one.
Executive Director West?
Sure, I'll chime in. Basically, the commission finds out when a case has been on hold for a long time because we're holding it for a criminal investigation, or we're part of a plea bargain settlement, then we'll be put into the plea and then it'll be presented to the commission at that time. I would also like to note that we have about 10 categories that have criminal implications that are automatically referred. So that includes gift limits, mass mailing of public expense, anonymous contributions, commingling of campaign funds. So we have a whole list of 10 that automatically get referred in order to make sure any kind of global resolution can happen.
And
Okay, thank you.
And correct me if I'm wrong, I think also there'd be a referral to the AG's office if there's a complaint filed against one of the commissioners. That would be another circumstance.
That is correct. We passed a regulation a couple of years ago where those are automatically taken out of our hands and sent to the Attorney General's office.
Excellent, thank you. Please proceed.
Okay. All right. And then the final resolution I will talk about is Streamline. Through the current program, the Enforcement Division can issue warning letters. We can refer respondents to participate in PREP, which stands for the Political Reform Education Program. This is a program where respondents can complete an educational course instead of paying a monetary fine. And finally, we can also negotiate a streamlined settlement. This settlement, unlike a mainline, doesn't necessarily include a full narrative, but the document will provide disclosure about the relevant violations. it does constitute an admission of the violations. The respondents sign that standardized form. It's the same for everybody other than the violations and the details. And they fully pay the penalty before it appears on the agenda. In addition, they could also be required to amend or file late statements to provide public disclosure.
Excellent. Quick point of clarification. So we have warning letters, we have Streamline here, and we have PrEP. Of those three, which result in the finding of an actual violation? Looks like Streamline settlement, absolutely you have an admission of violation. What about warning letters versus PrEP?
Warning letters is considered a finding of a violation. It just carries a $0 penalty. But you'll be provided with a warning letter that explains exactly what happened and what you did. And the PrEP closure letter.
Yeah, PrEP does not constitute a finding because it's like traffic school where we scrub it clean. So if there was a violation that falls under PrEP, if they take the course and pass the course within the required time frame, we won't hold that against them in the future. There's a repeat violation of the same offense.
Okay, and that's closed with the no action closure letter.
Correct.
Okay, so not a finding of a violation. Okay, that's helpful. Please continue.
So this is where I'll talk about the history of this program. So the commission has long sought ways to handle cases in a fair and efficient manner, particularly those types of cases where the public harm is lower. Over time, the commission has continued to review and improve the Streamline settlement program. We consider feedback from the enforcement division, from the regulated community, and at times changes are made to better address the commission's own enforcement policies. So these programs started in and around 1989 when the commission became aware of a growing practice of private attorneys general's actions that involved major donor filers. In essence, these private attorneys general would identify instances where major donors had failed to file their campaign statements, and they would basically try to go after them. So they have to file a request with the civil prosecutor, and if there was no response in 120 days, the private attorneys generals could then sue, and if successful, be awarded up to half of the amount that was not timely reported. So this type of failure to file is relatively common, and this prompted the commission to find a way to expedite the prosecution of these types of violations that are considered to be more minor and have lesser public harm. And thus, a streamlined settlement program was begun. At the time, only a few violations were processed this way. They would have included major donor reports and SCI non-filers and late 24-hour contribution reports. And the enforcement division would then present this abbreviated and standardized stipulation to the commission for approval. Streamline continued to be managed successfully as internal policy until 2015, when the commission approved a memorandum more formalizing this program. So this memo introduced some new violations, expanding what we could run through Streamline. We added SCI non-reporters to Streamline, as well as campaign late filing and late reporting. We added lobbying late filers, and we also handled annual fee cases through this program. Notably, the eligibility requirements for Streamline at this time were strict bright line rules. So for example, campaign late filers couldn't have had more than $25,000 on their campaign statement, or they would be automatically disqualified. So this had the effect of excluding committees from larger jurisdictions who would have otherwise qualified for Streamline. And then starting in 2018 and adopted in 19, we actually put Streamline into regulation. A few notable changes to the program at this time were that the commission made the eligibility requirements slightly more inclusive. It allowed more cases to be run through Streamline, to be resolved through Streamline. One way we did this was we scaled the monetary threshold to recognize the different population sizes of jurisdictions, since more populous jurisdictions like a statewide race tend to result in larger campaigns. So, and then in addition, there were 9 new violation types added to Streamline, and I will list them off. Lobbying late reporting, we had cash, campaign bank account, committee naming, advertisements were finally added to Streamline, record keeping, gift limit, some slate mailer organization non-filers, proper recusal, and major donor notifications. An annual fee was taken out because we no longer enforce that. So I'll continue with the history unless there's any questions about so far. Okay.
I do have,
Commissioner Wilson?
yeah, I do have a quick question for either one of you in terms of the process. When a Streamline case is decided, I've seen it on the various reports, and it's usually makes total sense. But what if a commissioner hypothetically didn't agree with a particular streamlining decision? Is there any way to challenge it, or is it, or not challenge it, but bring it before the full commission, or is it finalized once it's reported?
So the Streamline stipulation will be signed and paid for by the respondent, and then we notice it on the agenda. So they are currently in the executive staff report. And then after the commission meeting, that is when the chief of enforcement will sign it.
Oh, okay. So okay. I wasn't aware of of the actual timing.
Yeah.
I see the reports,
Yeah.
and I haven't at least personally questioned any, but I wondered, is there an avenue to be able to do that? And you've answered that question, so thank you.
Can I just fill in a
General
little?
Counsel Bainbridge?
Thank you. When it goes, it's up to the chief of enforcement to make the decision on the particular Streamline matter. The commission has delegated that authority on individual matters to be decided by the chief. The commission may weigh in if they disagree generally about a way a case was handled, but ultimately, because the commission has given this discretion to the chief of enforcement on individual cases that are listed, it is up to the chief of enforcement to make the decision ultimately whether to approve a particular Streamline case.
Commissioner Ortiz?
Thank you. The way that the case was handled, what does that mean?
The ultimate resolution. So what I'm saying is the commission doesn't have the power to change a particular case that has been reported out to them on an agenda, but can make comments generally about maybe that sort of case, or maybe generally how similar cases should be handled in the future. But the commission can't then direct the chief of enforcement to change that particular case, because this authority has been delegated by the commission to the chief of enforcement.
Thank you.
Commissioner Wilson?
I think in the current world that we live in, given that the current executive director, West, that she was involved in developing and educating the commissioners on this program. But maybe 20 years down the road, if you're not here, and the commission had a question about the process, they would have the authority to modify the regulation if they chose to do so.
Yes, that's exactly right. This is in the regulation, this process. Certainly the commission didn't want to do it this way. They could change it prior to, I think it was the 2019 amendments. All of the streamlines came before the commission for approval.
Okay, right, that makes sense. And that's why I said 20 years down the road, so.
Yeah, and at that meeting.
Thank you.
And at that meeting, the commission emphasized that they're providing this discretion because the Streamline regulations provide strict, as Senior Commission Counsel laid out, strict criteria that have to be followed in order for the Streamline case to be approved. Go ahead, Commissioner Brandt.
Okay. So more revisions. In 2020 and 2021, we amended things again. So we added Tier 2. So this expanded, again, the types of cases that could be resolved through Streamline. So these cases could include slightly more public harm, but now they will result in slightly higher Streamline penalties. Just for those cases that would otherwise qualify for this expedited Streamline process, this expedited settlement process. For example, prior to this change, a respondent who had made the same filing error within the last 5 years would have been totally disqualified from Streamline. It would have had to be a main line, even if the violation itself would have qualified on its own. And now we can offer that individual, that respondent, a tier 2 penalty. So it's still Streamline, it is still handled in the same way, just carries a higher penalty because you have that prior history. Another example is that under prior rules, an individual who had failed to disclose an economic interest on an SEI would have been disqualified if that interest had had business before that official. Under tier 2, that official could still be qualified, could still be eligible for Streamline if there was no evidence of a conflict. So again, higher penalties because there's slightly more public harm. In addition, we made major donor non-filers their own category instead of being folded into the same category as other committee types. And we also allow certain behested payment reporting violations to be eligible for Streamline. And the most recent change was in 23 and adopted in 24. The commission reorganized and revised Streamline again. The regulation is now organized by campaign violations, by ethics and lobbying, and a final section for the penalties. We did revise how the population of a committee's jurisdiction would impact eligibility, since a prior version of Streamline was found to unfairly exclude smaller jurisdictions. The commission changed the penalty structure and the amounts, removing a requirement to increase the penalty based on what stage of the litigation we were in. For example, prior programs required higher fines if the case had required the filing of certain documents. In addition, the commission added limited eligibility for 3 new violation types. So contribution limit violations are eligible in some limited circumstances. Section 84308, also referred to as the Levine Act, was added, allowing eligibility for instances of lower public harm, such as the failure to disclose a contribution over the limit. And finally, in some circumstances, respondents who are not in compliance with the Act's requirements for accepting recurring campaign contributions, they could also potentially be eligible for Streamline.
Commissioner Ortiz.
Yes, thank you. So can you tell me, is it 2 or 3 types of how you handle complaints? There is the Streamline tier 2. Is there another one?
It's going to be potentially a warning letter. So you might just get a letter with no fine. You could be referred to the PrEP program. You could receive a tier 1 fine or a tier 2.
That's what I was looking for. So there's tier 1
There's
and
tier
tier 2.
1. Yeah.
And then the Streamline.
Well, that's all Streamline.
Okay, I'm trying to figure out how you're different.
We just have, they're all Streamline, and then we will look at the individual violations and say, the regulation is organized by violation type, and it'll say, this is eligible for tier 1. But if this happens, it's now bumped up to tier 2.
So the first thing, Streamline.
Mhm.
And then you evaluate
Yes.
what is happening with that case, whether it needs to go to tier 1 or tier 2.
Yes, and we do it by violation. So a Streamline settlement may have both tier 1 counts and some tier 2. So it really just affects the penalty.
Okay.
Which we will go over this in more detail.
Okay, thank you.
Oh,
So-
there's one more
Commissioner
question.
Thank you. If I was delayed in asking the question on the previous slide. With regard to being new to the committee, I'm not quite sure what a major donor filer is. Is that just a person who is very well-to-do in the community and makes a big
Sure.
donation?
So it does refer to individuals can become major donor committees if they reach the threshold. So if they give $10,000 in monetary contributions to ballot measures or candidates, they will become a major donor committee. And that means that they have reporting requirements. So they will have to file a 461, a campaign disclosure statement to declare all of their contributions for that calendar year. And they also have to file any late contribution reports or late independent expenditure reports if that was applicable. So if those individuals do not file, that is a violation of the act and it can be resolved through Streamline.
Thank you.
So if the violation is eligible for a streamline resolution, we may proceed with a streamline penalty through a streamline stipulation. So in order to proceed with a streamline stipulation, all of the respondents must sign and submit a stipulation while paying the proposed penalty. We are willing to work with the respondent if the penalty is an issue and have done payment plans when appropriate. If the respondent has relevant prior history, it may impact their eligibility. Prior history includes a finding of the same violation type that has occurred or settled within the last 5 years. For example, if a respondent previously paid a Tier 1 penalty for a late campaign statement, if another violation of the same type occurs within the next 5 years, that violation cannot be resolved under Tier 1 and may be resolved under Tier 2. The streamline stipulation is then placed on the next commission agenda in the executive staff report, and after notice to the commission, will result in the acceptance of the stipulation and the closure of the case. Now, while Streamline does include many violations, not all violations fall under the program. Violations excluded from Streamline are conflicts of interest, campaign money laundering, personal use of campaign funds, as well as mass mailing or campaigning at public expense. Additionally, there may be a situation where the penalty in a streamlined case may be harsher than that if it were resolved with a mainline penalty. In such a situation, we would resolve the violation with a mainline stipulation. Other reasons to exclude a respondent from streamlined program include the level of public harm, the respondent's conduct, and their level of cooperation.
Commissioner Wilson?
I don't want to ask too many questions, but I am curious. Obviously, Tier 1 are less serious violations, Tier 2 are more serious. Let's say you have someone who has a prior Tier 2 violation, say in a prior year. Would they be eligible for the Streamline program for a similar violation, let's say a year or two later?
No.
Okay.
If it's the same violation type, no. If they had a violation that was a different type, a completely different type, then potentially. It would depend on the circumstances.
And that would be, those circumstances would be determined by council, even if it was a Tier 1 initially?
Yes.
Okay, all right, thank you.
So an additional consideration for eligibility in Streamline is the respondent's jurisdiction. Regarding campaign-related violations, the respondent is either a city and county committee, which includes state assembly committees, or a state committee, which includes the state senate committees. So a city and county committee is one where the jurisdiction has a population of 1 million or less. A state committee is one where the jurisdiction has a population of over 1 million. For example, in the city of Sacramento, there's a population of just about 500,000. That would make any committees running for a city office a city committee. But in the city of Los Angeles, there's a population of just under 4 million. So this would make any committees running for a city office in that city a state committee.
So after we review the potential violations, we've assessed the evidence, we've looked at it, staff will evaluate the case based on the Streamline regulations. We do look at the case as a whole, and then we consider each individual violation's eligibility. And we look to the specific regulation on that violation type. This evaluation, which is a standardized valuation, includes reviewing comparable cases with similar violations and fact patterns to support that we're reaching an appropriate and consistent resolution. After that initial evaluation is done, staff are required to send that evaluation to another enforcement division staff member for cross review. So this cross reviewer is typically another attorney or it's the intake manager, and they will check to make sure that the analysis was sound, complete, and fairly applies the factors. This is another way that we make sure our resolutions are consistent. And then after cross review, it's then reviewed by an assistant chief counsel. And then in some cases, it will also be reviewed by the chief. So we have touched on this a little bit, but I will go into a little more detail about the resolutions available within Streamline. So the Streamline regulations include factors to consider for issuing a warning letter, both for the overall case, but they also have criteria for individual violations. But in general, we're going to consider factors such as the level of public harm. We're going to look at the experience or sophistication of that respondent. We're going to look at the size of the committee. How much did they actually raise and spend? Was this committee new, or does it have a very long history? Did the candidate lose the election? Is the committee still open? We use these factors to help us determine whether this case is appropriate for a warning letter, or should it proceed to a fine. The regulations also formalized who is eligible for PrEP. So the goal here is to educate those respondents who can benefit from and who are interested in learning more about the Act's requirements in order to avoid future enforcement actions. So to participate, again, these respondents have to file all outstanding campaign statements or reports, or they have to amend as necessary to provide full transparency. Respondents will complete an educational course provided by the PrEP team, and then the case is closed with no further action. But if these respondents violate in the same way in the next 5 years, they do not qualify for PrEP. They will likely get a fine in that case. And then you've got our actual Streamline penalties. So these are the stipulations that you'll see noticed in the agenda on the executive staff report. So a stipulation can include both Tier 1 and Tier 2. It will depend on the individual facts of that violation type. So Tier 1 violations tend to carry less public harm, and that's reflected in their eligibility requirements and the ensuing penalty. So for example, the penalty range for a Tier 1 can be about 100 to 500 or 200 to 600. I think the most expensive is about 1,000. It will depend on the type of violation. That's in the third section of the Streamline regs. Tier 2 tends to be more serious. But there's still no facts or circumstances to suggest that they should be excluded from Streamline. The eligibility requirements are broader, but as a result, the penalties are higher. So in that case, the range will be 600 to 1,000, or typically 800 to 1,200. Again, that's going to depend on the violation type. The most expensive Tier 2 costs you $2,000 to start.
So each violation type has its own penalty structure, which includes a base penalty. Though there is an exception for cash, which uses a percentage of the violating activity. The penalty may be increased based off of the activity that was also not timely reported or the cost of the incorrect advertisement. For example, if a respondent failed to timely file a campaign statement, the penalty for the violation would include a percentage of the activity not reported. Additionally, the base penalty can also vary in $100 increments based on the public harm, the respondent's experience, the respondent's diligence in coming into compliance, or the cooperation during an investigation and during the settlement. So as of today, there are essentially 20 different violation types eligible for Streamline. They are divided into campaign-related violations and ethic and lobbying violations. Here are most of the campaign violations with recurring contributions and Section 84308, or the Levine Act, also included under 18360.1. So in the October presentation, we will go over most of the campaign-related violations as well as behested payment reports. We will discuss how these violations may be included or excluded from the Streamline program. And here are the ethic and lobbying violations. So in the November presentation, we will go over the remaining campaign-related violations as well as the ethics and lobbying violations. And we will also discuss how these violations may be included or excluded from the Streamline program. Thank you. We'll take any questions you may have.
Commissioner Ortiz?
Thank you. I just want to make a comment, and is to thank the Chair Silver and Executive Director West for this presentation. I mean, I don't know if I'm new or fairly new or whatever, but this is very informative, so thank you.
Thank you, and of course, thank you to staff for putting this
Yes,
together.
sorry.
And the slides were excellent. Looking forward to next month's presentation. Another thing to flag for those of you watching, we are currently scheduled to take up our regulations related to Streamline for potential changes in January. So we're hoping to engage with the regulated community as early as possible on that so we can develop a thoughtful policy in that area. Any other questions? Do we have any public comment on this item? Okay, hearing and seeing none. Thank you so much for the presentation. Really appreciate it.
We'll be back next month.
Okay, be waiting. Okay, so we're gonna move on to item number 10. That's gonna be our legislative update, and we'll be hearing from Senior FPPC Legislative Counsel Lindsay Nakano.
She survived.
She did. She's not done yet, though. We need some signatures from a certain individual.
Who shall be nameless.
Good morning, Ms. Nakano.
Morning, Mr. Chair, Commissioners. Good to see you all. Lindsay Nakano, Senior Legislative Counsel with the FPPC. So pretty quick update for you today. The legislature's in recess now. All of the bills that are listed as active in the legislation report, so all of the bills that still have their summaries included, were passed by the legislature and are now with the governor or soon will be with him for his decision. He has until October 12th to sign or veto bills. Since the last commission meeting, there was one notable amendment, SB 852, the committee bill that includes a couple separate PRA-related proposals, was amended to add another one of the commission's proposals to expand the prohibition on making contributions in state or local offices or office buildings, which was previously in another bill vehicle, so great news there. I also wanted to give a preview of what to expect over the next couple months in terms of legislation. Next month, I'll update the commission on the governor's decisions on all PRA bills. And in November, we will present new legislation ideas for 2026 for your consideration. If approved, staff will continue to develop those ideas and will look for authors. So that concludes my update today, but I'm happy to answer any questions.
Excellent. Commissioner Zettel?
Very much. I appreciate the work that you've put into this. You've come a long way. Anyway, I have a question regarding AB 953. As you say, it's on the governor's desk right now. But I had a question on lawfully admitted permanent resident. And this is on page 5 of this item. And could you define the not a lawfully admitted permanent resident? That is Pacheco and Olanis, AB 953.
Yes, that is defined in statute. Let me pull up the definition.
I'm sorry, I should have given you a heads up before.
Oh, not a problem.
Would a DACA student be a not?
Sorry about that. The bill specifically excludes DACA recipients from the prohibition, so they would, under this bill, be allowed to make contributions related to ballot measures.
But not be allowed to vote. clarification.
Right. This does not touch voting.
Okay. Are they considered a lawfully admitted permanent resident? And who are lawfully admitted permanent residents?
It's not defined in this statute. I think it tracks federal law. I don't have the definition in front of me. It's not in this statute, but I could provide that to you.
Sometime maybe.
After finding.
Interesting. Thank you for following. Anyway,
It's my understanding. Go ahead, Commissioner Zettel.
Thank you. And there are several really good bills in this package. As a legislator, some of them I thought were already in law. So thank you for, sponsoring many of these bills that are for better government, ethical behavior, and so forth. Thank you. I could enumerate those, but I won't.
Well, I appreciate you saying that. I mean, that's consistent with the theme for our legislative package this year, and that was to make the law consistent with the expectations of the public. So specifically, one of the bills that Ms. Nakano laid out related to the receipt of campaign contributions in a public building. I would think most Californians, if you asked them if that was permissible, they would say it's absolutely not permissible. But there was a gap in that area of the law that we wanted to fix and make it clear that that sort of activity under the law is not permissible.
And one more question. Sorry.
Sure.
Okay,
No,
I'll
go
wait.
ahead. Commissioner Zettel, go ahead.
Okay, thank you. With SB 42, and that is on page 11 of that same agenda item, 10, I believe. Umberg, Allen, and Cervantes. This is a measure that will ultimately go to voters in November of next year, as stated here, but the governor must sign it first. My concern with public financing, I just want to make an editorial comment, is that the state of California already is billions of dollars underwater in debt, as most of our cities and counties. As someone who has run, I'm a school board member, I've run several elections, I'd have to say that if you can't manage to get your community to do $10 donations so that you can qualify to be an official, open a campaign statement to file, or the name of that, you know what I mean, I believe. You have to show that, and they say that you have to show support, but I'm not sure that California is ready at this time to mandate additional expenses for state and local governments to fund these things. I believe if people are motivated, it doesn't take money. It takes volunteers to get the vote out, and certainly some money to print campaign mailers. That's just my editorial comment. Thank you.
Well, thank you. Commissioner Brandt?
So I have a question that's not substantive, but it's process. Were there any bills of our bills that you had to stay late at night on the final night? Sorry, I miss these days. I have to admit.
Nothing too dramatic.
Okay.
Yeah.
Darn.
Commissioner Wilson?
We'll have to, Council Nakano, perhaps you can get Commissioner Brandt some tapes from the end of session he can watch. But I do have a question regarding SB 300. It's a bill, it's a bill not moving forward. It's a 2-year bill. In terms of that particular measure, what is the actual status? I mean, I know it's still in what committee, but do you know if it's received bipartisan support, general support? Kind of what does it look like moving into the second year of the 2-year session? SB 300.
Looking if there's any records of votes. Its first hearing in the Elections Committee was canceled at the request of the author, so it received no votes in any committee or either house. So no indication, at least on the record, of how people feel about it at this time.
Okay, thank you. I know that particular measure was raised by a commissioner at a prior meeting, so thank you.
Can I ask?
Commissioner Ortiz?
Yes, thank you. How about SB 458 that is no moving forward? Is it dead or is it still alive? That's the yellow umber ballot measure titles.
Double checking, but I believe that was held in the Appropriations Committee, so that is done unless reintroduced in a separate bill vehicle.
Okay, thank you.
But I suspect that idea could be coming back, because that was the second time, kind of similar idea.
Multiple times,
Yeah,
yes.
multiple times. Commissioner Zettel?
Quick definition request on that 15 to 16 page of the SB 321 Cervantes. Late signature curing expenditure reports. What is a late signature cure being defined as?
Pull that up to refresh my memory. Okay, they did define it in the bill. It's an expenditure made by a committee related to ballot curing activities. Any expenditure made for the purpose of contacting a person regarding a signature verification statement or unsigned verification envelope statement received pursuant to the Elections Code. As I recall, it related to activities that campaigns might use to encourage voters who had not yet or whose signature was not verified to correct that. So if campaigns were spending funds to encourage individuals to correct their signatures, that they would need to, that's what that definition refers to.
Thank you, I appreciate that.
Commissioner Ortiz?
I want to make the clarification, the statement I just made, that that bill 458, that push has been happening for 20 years. I don't want to be challenged, so I'm just going to say several years.
Well, thank you for that clarification. Just worth noting, since it doesn't look like we have any more comments on specific pieces of legislation, I just want to highlight what an excellent job the legal division, in particular, Ms. Nakano, did this session. I believe we had 7 sponsored bills that we secured authors for. Of those 7, 1 has already been signed into law, correct? And then we have, is it 5 others that are before the governor? And then 1 was made into a 2-year bill.
Right.
This is my first time working on legislation, but it sounds like that's a pretty good record. So excellent job to all involved. Thank you. Let the record show a clap from Commissioner Ortiz. Any public comment on this item? Okay. Well, thank you, Ms. Nakano.
Thank you.
Let's move on to item number 11, appointment of a vice chair. No one to welcome up at the desk for this one. I'll take care of it. The commission's governance policy calls for the commission to appoint a vice chair to preside over commission meetings if the chair is absent. This position is often held by one of the 2 commissioners from the party that is not in the majority. This is meant to be a demonstration of the commission's commitment to bipartisanship. With that said, what's made our past vice chairs so successful is not just their party registration, but rather their commitment to the principles that the FPPC stands for, of transparency, accountability, and upholding public trust, as well as being an excellent collaborator. With that in mind, I would like to nominate Commissioner Zettel to be vice chair and move that the commission approve that nomination. First, we'll take any public comment to the extent that there is any. Hearing and seeing none, I'll make that motion. The commission approve nomination of Commissioner Zettel as vice chair. Do I have a second?
Second.
Oh, that's not, I think Commissioner Brandt won the race. Okay, Ms. Vo.
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Commissioner Zettel,
Aye,
Chair
and I
Silver.
just hope that the chair is never sick. He is an act to follow. And thank you very much to fellow commissioners. I did suggest all of your names, but I guess I drew the short straw. Thank you. I'm humbled.
Well, thank you for assuming the role. Aye.
Motion
Well,
passes.
Excellent. Okay, let's move on to item number 12, and that's going to be appointment of a Law and Policy Committee member. One of those seats on the Law and Policy Committee is currently vacant after Commissioner Baker left the commission at the end of her term. Governance policy calls for the chair to nominate a second member of each committee to be approved by a vote of the commission. I therefore nominate Commissioner Brandt to be a member of the Law and Policy Committee and move the commission approve this nomination. Do we have any public comment? Hearing and seeing none.
Second.
Excellent. Isabel?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Commissioner Zettel,
Aye.
Chair Silver.
Aye.
Motion passes.
Okay, let's move on to item number 13. That's our executive staff reports. We're going to start with our chief, Kendall Brombrake.
Good morning again, Chair Silver, Commissioners. The Executive Staff Report from the Enforcement Division is as submitted. However, I'm happy to answer any questions you may have.
Excellent. I want to take this opportunity to, again, thank you, Assistant Chiefs Burton and Brereton, for the hard work that they put in while we were in the interim between enforcement chiefs. So thank you again for your work and for the Enforcement Division's work in general during that period. Any other comments on the enforcement report? No? Okay. Well, thank you. Let's move on to Audits and Assistance Division. Sharada Shah, our chief of that division. Good morning, Ms. Shah.
Good morning. My report for this month is as submitted. However, I do want to highlight that we just had the public draw for this for selection of local jurisdictions and Superior Court offices, and that result has been posted to our website.
Excellent. And it's available on YouTube as well if you want to
It
watch
is.
the actual draw?
Yes, the recording is available on YouTube.
Okay, perfect. Any questions or comments for commissioners? Commissioner Wilson?
Thank you. Chief Shaw, just have a kind of a technical question. When there's a audit done by the Franchise Tax Board, could you kind of explain just briefly kind of what that process is? You've done this before. And then how is the case actually finalized, either internally or by the commission?
Yeah, so when we do a public draw, we send over the results to FTB. They take it from there. They notify the candidates or the committees who are selected for an audit, or in this case, the local jurisdictions. They will notify them. They will go ahead and do the audit. Once they are done with the audit and the audit report has been issued, it is sent over to FPPC for review. So they send it over to our enforcement division. And then if there are any violations or findings noted, then the enforcement division will take it from there.
Sorry about that. And I also assume that based on the Enforcement Division's analysis of the case, it could still be eligible for a streamlining program. Is that correct, or would it have to come before the full commission?
That would be an enforcement question.
Okay, all right.
Executive Director West?
I'll fill in. Yes, so it would be handled as any referral would be handled, but it goes through the same evaluation and the same criteria.
And
Commissioner Ortiz?
thank you. And following in the process, how far back do the audits are susceptible? How far back committees are susceptible to audit?
Oh, yeah, so the audit period, we go off of election years. So if it was a 2022 election, then we will say a candidate ABC has been selected. So we look at when their first intention statement was filed, or the statement of organization, I believe. So from there, the audit period starts when they file to be a committee until they close their books.
No, what I'm asking is any committee, how far are the committees liable to be audited? How far in time? 3 years, 4 years?
It is within their election period. So from the time that they file the intention statement is there when their audit period starts. So we wouldn't be auditing outside of the period.
Did you need follow-up? Okay, so basically the statute of limitations for the FPPC in general is 5 years for administrative prosecution, 4 years for criminal prosecution, and then the auditors have certain statutory deadlines on when they have to finish audits. So it's those statutory deadlines are how long you have to keep your records. The record keeping statute is 4 years.
4 years.
So, but it's usually from the date you filed it, so
Yeah.
it's not like from today. So the audit period, Chief Shaw, that would be, how long is your statutory audit period?
I see. Okay. So so to answer your question, from the time they file, but if we have 2 years
2 years.
2 years.
Okay, thank you.
to complete the audit, yes.
Okay, great. Any other questions, commissioners? No? Okay, thank you, Michelle.
Thank you.
Okay, let's move on to the legal division. General Counsel Bainbridge.
You stole my thunder earlier with the Streamline regs that will be coming up in January for pre-notice. So the presentations you'll be getting over the next couple months, including the one today, are primers to get you thinking about it, and then we'll hopefully get some input and have a draft ready for you in January on those regulations. Nothing to add other than that. I'll take any questions.
Excellent, thank you. I'd like to highlight that myself and Suki Barar, as well as Tara Stock from our enforcement division, presented to the California Political Treasurers Association. I believe that was back in August on various different topics. Really appreciate the opportunity to engage with them. I also presented to the California Political Attorneys Association earlier this month on various different issues related to the FPPC. And I hope we can keep that going and engage with the regulated community as much as possible. Any other comments from commissioners? Okay. Thank you, Mr. Bainbridge. Let's move on to our Administration and Technology Division. Dr. Wang, good morning. Oh, Commissioner Zettel, my apologies. Go ahead.
Thank you. Just a weird question. Do you ever allow one other commissioner who would like to hear your presentation to attend or to listen into it? I've always been kind of a groupie, and I wondered if you want, I might on occasion think, well, this is a very interesting topic. Is that?
Absolutely. So long as we don't have any issues related to Bagley-Keene, the open
Well,
meeting
yeah.
requirements, I welcome it. I think it'd be excellent.
Yeah, perhaps I could cue the audience clap at this. I always start that.
No, I think she's talking about coming to our presentation.
presentations.
With stakeholders. Oh, yeah. Excellent. Well, thank you, Commissioner Zettel. Dr. Wang.
Good morning, commissioners, chairs. Admin report will submit as it is. I'm here to happy to answer all the questions you have.
Any questions, comments from commissioners? Okay, hearing and seeing none. Thank you, Dr. Wang. Okay, and lastly, we have our executive director update from our executive director, Galena West.
Nope, nothing really to add, just excited about the January Streamline regs. So as you see these presentations, please take notes as you're looking at them. We do a review of Streamline about every 2 years to try to keep it up with what the commission wants and to make sure that everything is reflected in the regulations, so that the enforcement will go out and apply for you, so.
Excellent. Any public comment on our enforcement staff reports? Okay, hearing and seeing none, we're going to move on to item number 14, and that is closed session. I believe we do a motion to go into closed session. Is that correct? No, we do not need a motion to go into closed session. So we will be moving into closed session, and we will come back following that to take up item 15. We're back from closed session. We're going to move on to item 15, general item. That's going to be commissioner comments and proposed future agenda items. Do we have any commissioner comments or future agenda item?
Yes, I do. Thank you. More and more public agencies are facing serious budget deficits. So as a natural outcome, they will want to go to the ballot to raise revenues and might rely on general counsels for advice, whether they can issue a communication, a mailer that is either information or advocacy. What I would like to propose is a program, an FPPC, an education program for general counsel. Because board members or anybody like that will want to go to their city, county, school, public, special district to ask them if that is permissible. And there is confusion, I think, exists about what is permissible according to the act. So that's what I would like to propose. How the educational program is developed is, I will leave it up to staff.
Commissioner Wilson?
I think Commissioner Ortiz is proposing a good idea, and I think General Counsel Bainbridge has, along with our Executive Director West, they've been very proactive in terms of, with the support of the chair, in terms of advocating for, educational programs, webinars, and so forth. So if you go to the FPPC's website, you'll find that there are a lot of proactive programs in place, and implementing a program along these lines would be consistent with what Commissioner Ortiz is proposing. But I would defer to senior staff to comment additionally.
Any other comment from commissioners? General Counsel, Executive Director West?
I mean, at this point, this is just an item for a future agenda, so I think we could probably discuss that at the next meeting if we wanted to agendize this issue for maybe coming up with a plan along the lines of what Commissioner Ortiz is suggesting.
I think that'd be a great idea. We don't have to make any sort of motion in order to have that on a future agenda, correct?
Correct.
Okay, excellent. Thank you. Any public comment on this item? Okay, hearing and seeing none, I'm going to move to adjourn.
Motion to adjourn.
Okay, we have a second. Ms. Vo.
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Commissioner Zettel?
Aye.
Chair Silver?
Aye.
Meeting adjourned.
Thank you.
Thank you.